Afternoon, everyone. Thank you for joining this IACC session in our webinar series. My name is Susanna Noshad, and I'm counsel in Khaitan Co Singapore office. My practice focuses on disputes, investigations, and regulatory compliance, including cross-border internal investigations and white-collar and corporate governance matters, with a particular regional focus on the US and Singapore. Today's session is designed to be practical and cross-border because whistleblowing, as we all know, is no longer a local issue that stays inside the organization. Including US whistleblower reward programs, and may trigger multi-agency scrutiny, sanctions and AML-related questions, and of course, follow-on civil exposure. Often this can happen before the board or the general counsel's office even have had a chance to kind of fully stabilize the facts. Before we begin, we are honored to have the presidential address by Mr. Manoj Singh. Just a brief introduction about him, although I think he needs no introduction. Mr. Manoj K. Singh is a renowned litigator and counselor. He has over 2 decades of rich experience of advising clients on myriad legal issues. He's also a board member of the North India Regional Council of Indo-American Chamber of Commerce. So now I will invite Mr. Singh to deliver the presidential address.
Thank you, Sujan. Thank you very much for kind words. And first of all, thanks to Dr. Lalit, Bhasin, Patrick, Iris, Prem Kumar, and definitely thanks to my dear friend Ajay. So perhaps this is the time when we really need to think about the topic. Whistleblower Without Borders, US reward programs, India vessel mechanism, and cross-border crisis readiness. See, to me, whistleblower is a very important, they play a very important function. And we are convening at a time when integrity risk transcend jurisdictions. Data travels at the light of the speed of the, it's such a speed, light travels. Now, things about the misconduct, if left unchecked, can travel just as fast. In this environment, the courage of a whistleblower and the credibility of the system that protect them have never been more important. Why whistleblowing matters in a global context, not India only. Allow me to begin with a brief story. I will not take the name or the jurisdiction. A few years ago, this is a case study, in fact. A few years ago, a mid-level finance employee at a multinational, let call the person A, noticed unusual consultancy payments routed through a once country entity. The amounts were small at first, but the pattern was unmistakable. On raising the concern internally, A was told, these decisions are taken at corporate, please stay within your lane. We keep on hearing such kind of comments. Months later, A's tip submitted separately to a global regulator helped expose a $200 million scheme spanning across the Africa, etc., etc. Now, what this captures, that whistleblowing is no longer about one company or one country. It is an early warning system for the world's interconnected market. A system that works only when individuals feel safe to speak and when systems see beyond borders. If whistleblowers are not feeling safe, the quality and the quantity of whistle would decrease drastically. Whistleblowers, in essence, have become the first line of defense in the global battle against corporate malfeasance. They are not merely informants. They are guardians of institutional integrity. We must keep on looking at them from this perspective. Research consistently demonstrates that whistleblower tips remains one of the most effective means of detecting fraud. Across the world, legislature, regulators, and international bodies have come to recognize that without robust whistleblower protection and in certain jurisdictions, meaningful financial incentives, individuals will remain reluctant to report wrongdoing due to fear of retaliation, professional ostracism, or worse. Sometimes the financial gain also invite people to report such kind of issues. A tip in Bengaluru can uncover a bribe payments booked through a shell in the Caribbean to influence procurement in Africa somewhere, listed on an exchange in New York or London or Singapore. Our framework must therefore meet a global test. That is the point which I'm making today. There must be a framework, or we should work toward a framework which must meet a global test. And what is the test? Are they accessible across borders? Are they credible across agencies? And are they resilient under pressure? Now, let us come to the point, comparative overview, US reward program versus India Vigil mechanism. Definitely, I mean, this comparison can have a various shades due to the jurisdictional issue, legal issue, etc. But at least we should attempt to examine so that we can go towards the global parameters, if I would say. Now, if we look at the design philosophy, United States Reward Program, notably the SACC Whistleblower Program, or the CFTC Commodity Futures Trading Commission Program, or the IRS Internal Revenue Service Program, are built on deterrence through detection. They combine confidentiality, anti-retaliation protections, and monetary awards based on sanctions collected. The model recognizes that complex cross-border securities and commodities violations often surface only when insiders, employees, intermediaries, or counterparties are incentivized to step forward. Apart from the protection, the incentive has been seen as one of the major reasons that people come forward, that there is some incentive after the wall. Now, India Vigil mechanism, mandated under the Companies Act 2013 and also reflected in SEBI's listing obligation, is rooted in internal accountability. But that is the one of the basic difference, I would say. It requires companies to establish a mechanism for directors and employees to report genuine concerns, typically to an audit committee or an independent director. Rather than relying primarily on financial incentives, it places trust in organizational culture and institutional conscience. Access and anonymity, second issue. One is the design philosophy. So this is the basic design of India and US. And another is the access and anonymity. Anonymity is very important for the whistleblowers. Nobody wants to come in the open against a powerful organization against whom he or she is whistleblowing. US programs permit tips to be submitted confidentially and through counsel anonymously. The entity can remain secret even during investigations and proceeding, subject to due process and the need to test evidence. This has proven decisive in encouraging high quality reports and complex systems. India's Vigil mechanism places a premium on confidentiality and have evolved in recent years. A number of leading Indian companies now operate anonymous hotlines, digital reporting portals, and third-party managed channels. However, a real challenge persists. Adoption remains uneven, and in many organizations, whistleblowers still face the practical difficulty of identity exposure during internal inquiries. Strengthening anonymity in Indian scenario, particularly in mid-sized and smaller listed companies, is a key area which require a progress. Then incentive and outcome. Third examination. US reward program tie eligibility to the originality and usefulness of the information, to the recovery of monetary sanctions above threshold. Awards can be significant, designed not to pay for ethics, but to offset the genuine personal and professional risk whistleblower undertake. This has yielded a large pipeline of actionable cross-border tips and landmark informants outcomes. India approach relies on duty, ethics, and governance culture. Many organizations have done commendable work in strengthening speak-up channels, training and no retaliation pledges, etc., etc. However, the challenge is clear. Without tangible incentive, and that is important, without tangible incentives or sufficiently strong information-backed protections, many potential whistleblowers remain reluctant to come forward. And I think India need to work in this area. Then governance, process, and trust. The US model directs whistleblower submission straight to independent regulator. So, I mean, the process ensure the trust some way because it is quite recognized mechanism and whistleblowing cases are coming more and more there. However, Indian model is company-led. the first receiver is often the entity potentially implicated. I mean, this is a big drop. I would say this is a concern to me or flaw. Best in class companies mitigate this through external ombud services. Now, again, who select those external services need to be seen, because that again goes back to the square one, that the people who are implicated may have engaged those services. Audit committee oversight and documented non-interference protocol. Now, who design audit committee? I mean, we really need to think over it, and we have to create a system which is uh, where at least the people who are implicated should not be in the controlling situations. Challenges on both sides. Last inquiry. For the US, managing volume and quality, ensuring timely payouts, safeguarding against frivolous or opportunistic tips, and coordinating multi-agency, multi-jurisdiction actions without jeopardizing due process is the key challenge. Because when this kind of system is there and there is some large incentives are there on the stake, people tend to keep on sending some reports, some complaints, and etc. So they need to manage. To me, volume and quantity need to be managed. For India, ensuring consistency across a heterogeneous corporate landscape, strengthening anti-retaliation enforcement, increasing whistleblower confidence in fairness and internal inquiry. This is very important. We need to do something whereby we can increase the whistleblower confidence in fairness and internal inquiries, and bridging the gap between corporate findings and external enforcement where warranted. Neither approach is inherently superior or inferior. Rather, they reflect different regulatory philosophies suited to different contexts. The ideal framework I would submit incorporates element of both: meaningful incentives where appropriate, robust protection against retaliation, a strong governance, infrastructure, and effective enforcement mechanism. So effective enforcement mechanism is the key. And effective enforcement mechanism can be both ways. So unnecessarily people coming as a whistleblower for, I mean, some retaliation, some to settle some personal scores, etc., etc. Against them also there should be an enforcement mechanism. Cross-border cooperation and crisis readiness is the one issue which we must look at it. I mean, the biggest challenge as a lawyer, I mean, which I can feel is, I mean, one act can be seen as a on the scale of 10 act of a second degree culpability, and in the other jurisdictions same act can be seen as a sixth or seventh or eighth degree culpability. So how to iron out in the case of whistleblower processes, right? So that is one major issue. Financial crimes are increasingly transnational in nature. Bribery schemes may originate in one jurisdiction, flow through intermediaries in another, and ultimately harm investor or consumers in a third country. Traditional enforcement approaches bound by territorial limitation, divergent legal standard, and cumbersome mutual legal assistance processes struggle to keep pace with the sophistication and speed of cross-border misconduct. So these three issues, I mean, territorial jurisdiction limitation foundations, divergent legal standards, and cumbersome mutual legal assistance processes need to be ironed out. Several promising developments, however, deserve our attention. In Europe, the EU Whistleblower Directive of 2019 has established minimum standards for whistleblower protection across all member states, requiring effective confidential reporting channels and robust protection against retaliation. These creates a foundation upon which cross-border cooperation can be built. So cross-border harmonization will create an environment which will somehow, some way ensure the same treatment to every whistleblower in any jurisdiction in a multi-jurisdictional kind of whistleblowing. So if I may end today my issue, what are the key recommendations or key insight? Number one, establish minimum global protection standard. Two, enable cross-border recognition of whistleblower award. Build secure, confidential cross-border reporting channels. Four, train regulators and compliance teams for cross-border misconduct. Fifth, pilot incentive-based whistleblower model. Sixth, build corporate crisis readiness for cross-border disclosures. Seventh, leverage the India-US trade deal to harmonize integrity system. So in today's world, and for this forum, in today's context, to me, this is the most important point, which other speaker also going to put some light, that how India-US trade deal can harmonize these systems. Conclusion is that silence is expensive, truth is priceless. In a borderless economy, every credible tip is a chance to correct course before reputations, valuations, and lives are damaged. Look, if we want cleaner markets and stronger companies, we must make it safer, faster, and more worthwhile to speak up. So, suppose, certain jurisdiction, many jurisdiction, there is a different legal system, there is an overload on legal system. It may take years to come to the conclusion, and certain jurisdictions are faster. Now, how to marry between both of them? We need to think of some solution in case of this particular subject, whistleblowing. Ladies and gentlemen, let me leave you with this. Whistleblowing is not a compliance checkbox. It is a moral courage in action. Individuals risking everything to stand for what is right. So therefore, please provide for a effective enforcement mechanism, and let us create an environment for it. Let us put an effort toward it. Thank you very much. Thank you very much, Suzanne, again for organizing this. Thank you very much. I'm very glad to be here, Suzanne. Thank you.
Thank you, Mr. Singh, for setting the context so clearly. May I now invite Dr. Bhasin for the opening remarks. A little bit of introduction about him. Dr. Bhasin is the founder and managing partner of Bhasin
No
Co.
need to introduce. No need to introduce. Yeah, that's all right. I'm among friends, I think, and I think we know each other very well. As a matter of protocol, when the president speaks, you see, then others just follow, you see. Therefore, when Mr. Manoj Singh has spoken, I can only say that I adopt whatever the regional president, Mr. Manoj Singh, has said. And he has very elaborately dealt with not only the scenario in India, but also the implications, you see, which has in view of the globalization of everything which is happening, globalization of commerce, globalization of trade, and mutual cooperation, particularly between the United States and India. I will only say that India is on the march now. Last 2 months have seen very historical developments, very monumental developments taking place in India. First, the FTA with United Kingdom, then with the trade mother of the deal, that is the trade agreement with EU, then the interim agreement with the United States, now the agreements with France, and above all, the recent summit which is going to conclude today, that is the AI summit, which is taking place in India, in which 91 jurisdictions are participating. That is very relevant. And we cannot minimize the role of artificial intelligence when we discuss any subject, and particularly the subject of whistleblowers, because artificial intelligence is reshaping the landscape of international trade, compliance, offering unprecedented opportunities for efficiency, transparency, and risk mitigation. Yet, its integration into global trade system also introduces complex legal, ethical, and regulatory challenges. And as Mr. Manoj Singh rightly pointed out, that a whistleblower is like a custodian, guardian of ethics and the correct compliances. That is where the role of the whistleblower comes in. And whistleblowing, as the introduction to this webinar says, has truly become borderless. A concern that surfaces inside in India an Indian business unit can now be routed quickly and discreetly into the US reward frameworks and enforcement channels, triggering multi agency scrutiny, including sanctions and money laundering angles, and follow on civil exposure, often before the board or the General Counsel's office, and this has fully stabilized the facts. The practical reality is that where there is any US nexus, external reporting is no longer a last resort. For employees, vendors, and intermediaries, it can be a commercially rational option. I am very happy to see, as the past national president of Indo-American Chamber of Commerce, that this initiative has been taken by the North India Council under the presidentship of Mr. Manoj Singh and with the active help of the Secretariat led by Ms. Kashish Tyagi and the organization abilities of my friend Mr. Ajay Bhargav, who has rightly roped in Susanna Naushad to moderate this very important webinar. And the participants are from global jurisdictions. You see, we have Mr. Patrick Linehan, who's a partner of Steptoe, MS Iris Bennett, partner again of Steptoe, and Mr. Prem Kumar, head of ethics and compliance of Takeda. So I'm sure these experts will give their most valuable inputs. And now over to you, Susanna, for taking the webinar forward by the presentations and your questions to the panelists and all. Thank you. Thank you very much.
Thank you, Dr. Bhasin. Just a quick housekeeping note to all our attendees. Please feel free to drop in your questions in the Q&A section in the chat box. We will aim to take audience questions towards the end, depending on time. Also, now, of course, Dr. Bhasin has already introduced our panelists, but just a little more introduction about them. We have with us Patrick Linehan. He's a partner in Steptoe LLP, a global law firm. He's based out of the DC office. Patrick has a diverse practice and focuses on representing corporate and individual clients in internal investigations, criminal investigations, and trials, and civil litigation. Our second panelist is Iris Bennett. Iris is also a partner with Steptoe in the DC office. She has more than 2 decades of experience representing companies and individuals in the defense and resolution of criminal and civil investigations by the US DOJ and He's the director and head of ethics and compliance for India and Southeast Asia at Takeda, and leads the ethics and compliance function across markets with vastly different regulatory environments, cultural contexts, and governance frameworks. His mandate, I think, basically is building compliance programs that scale across complexity while maintaining zero tolerance for ethical compromise. As you would already know, Takeda is a Japanese multinational pharmaceutical company with massive operations in both India and the US. The closing remarks for this session will be given by Mr. Ajay Bhargav, who's a senior partner in the Delhi NCR office of Khaitan Company, and he also co-leads the litigation practice of Khaitan Company. Just to give a brief background about the structure, so we will move in 4 steps. Initially, Step 2 will walk us through the US whistleblower ecosystem and the US nexus hooks that can pull an India-linked matter into the US jurisdiction, and essentially what happens once an external tip is made. Secondly, we will hear the in-house perspective on how to respond in the first 24 to 72 hours in a way that is fast, credible, and defensible. Thirdly, I will just briefly cover the Indian governance and legal baseline as a bridge. And finally, we will close with cross-border readiness and a concrete roadmap. With that background, let's move straight into the substance. Just one question to get a GC perspective first, and post that we will start with the US hooks. So my first question to Prem Kumar is that, in your experience, what do you think is the single most common failure mode in a cross-border whistleblower matter?
Thanks, Suzanne, for inviting me in this great topic and a very timely topic and very close to my heart as well, and with the esteemed panelists and the speakers and president. It's an honor to be here. In my perspective, from in-house legal ethics and compliance perspective, the most common failure that comes to that faces by the company is not the companies do not have a policy. All the companies have the policy, but as we say that just because you practice on the simulator, you cannot take off the flight when it comes to the actual practice. So practicing on simulator is completely different thing, but when it comes to the actual flying the aircraft is a completely different practice needed. It requires experience. And the most common mistake, what I have seen or what has happened many times is that the first response is either too slow or too fragmented. While when the whistleblower happens and there is a time to respond, the slowness makes the external reporting more attractive for the whistleblowers. They realize that the organization is not serious or taking its own time. And it becomes more attractive for them to go external, become external whistleblower. When at the same time, when fragmentation comes, it creates contradictions, that the fragmenting response, that whenever people do not have very synthesized and concise or the single way of responding to the whistleblower concerns which is raised, that creates confusion. And it also creates situations which is contradictory to the credibility to the organization and difficult to reconcile at the later stage. And therefore, what I always suggest is that a disciplined first response where the data preservation is scoping of this, the whistleblower allegations, whatever the allegations is, the governance and the communication controls, who will be speaking to whom and what, often determines whether the company can manage the matter credibly if the external authority will be involved. So I think this three aspects of initial 24 to 48, 72 hours of response: data preservation, scoping, governance, and communication control. Structuring the structured communication is the key thing to credibly and responsibly respond to a whistleblower situation.
Thank you so much. Moving to the US landscape, Patrick, my question to you is, in fact, it's not even a question. I think to begin with, can you just walk us through the US whistleblower ecosystem at a practical level? What programs matter most, and what do you think incentives actually look like?
Yeah, happy to do that, and appreciate being part of this esteemed panel and to speak to such a sophisticated audience. There are a number of whistleblower programs in various different areas of the U.S. I'm going to focus on what I view as the four primary ones, particularly as relates to in terms of exposure of non-U.S. companies like India. And then Iris will talk about sort of the jurisdictional nexuses between non-U.S. companies and the programs themselves. I'll start with the one that I think is probably most familiar to folks on this call, which is the SEC Whistleblower Program. That essentially is a program by which either alone or through counsel, you submit a whistleblower will submit a written submission making allegations of violations of the federal securities laws. And most frequently, those are arising out of FCPA allegations that there are briberies being paid to foreign public officials. That the SEC has jurisdiction over those matters, and will open up investigations based on whistleblower complaints. They may even, in fact, make criminal referrals to DOJ. The second one I wanted to talk about is a more formalistic one, which is the False Claims Act. False Claims Act is a civil enforcement statute that imposes liability for companies that either submit false claims or submit false documentation to avoid government obligations. And the False Claims Act program is actually not just simply a written submission to the government. You actually have to file with a lawyer, file a sealed complaint that triggers that triggers the initiation of a government investigation, which can go on from anywhere from 6 months to a number of years. And then the government will decide to intervene depending on the merits of what they find in the investigation. There is also a newer criminal division pilot program, which is intended to fill the gaps created by the availability of whistleblower coverage on the SEC program and on the False Claims Act program. That covers, and that's a relatively new and sort of untested program that covers financial institutions fraud. It covers private payer healthcare fraud, domestic and foreign bribery, to the extent those allegations are not covered by either the SEC program or the False Claims Act program. And then the last one I'll mention is there's an antitrust whistleblower program. This is probably the newest. This is the newest of the 4 programs. And in that case, there needs to be a connection to the U.S. Postal Service. And that really goes after, incentivizes allegations that companies are engaging in price coordination, bid rigging, market allocation, per se offenses of the Sherman Act. The two common denominators of all of these programs is, number one, they're all financially incentivized. Whistleblowers can receive anywhere from between 15 and 30%, depending on the program, 15 to 30% of whatever the government brings in as a result of any resolution that arises from the whistleblowing. And then they all have some sort of whistleblower protection. In some cases, it provides a cause of action for the whistleblower to sue the company for any retaliatory actions that have been made in response to their whistleblowing. In the case of the pilot program, there is no express right of action, but there is a recognition by the Department of Justice that if there is any whistleblowing retaliation, that they will consider bringing charges of obstruction against the company. So that's the landscape of whistleblowing. It's obviously a little different than in India because of all of the financial incentives and the potential abuse of process that those financial incentives may give rise to, which is why it's important to deal with this very specifically and in a focused way from the perspective of companies. But I'll let Iris. Well, that's all. I don't know if Susanna, you have a question that you want to pose to Iris, or I could just hand the microphone.
I do, but thank you for your answer. And, that certainly clarifies why external reporting is not a remote possibility anymore and how actually incentives can shape behavior. The next issue that Prem also pointed out is that in-house teams often struggle with jurisdiction. So we have seen that even when facts are largely outside the US, certain connections can bring the matter within the US focus. So Iris, let me come to you on that. What do you think are the most common US nexus hooks that can pull an India-linked matter into the US jurisdiction?
Sure, happy to address that. And it's great to speak with everyone. So first of all, the most common is there are many. 2 things that I want to mention at the outset is one, the hook that will trigger the possibility for a U.S. enforcement action is going to be defined by the underlying statute. So in the U.S. system, when our Congress passes a law, then within like a criminal law or a civil fraud law, then it's within that statute that it will define what is it that could draw a non-U.S. actor into U.S. jurisdiction. So it will depend based on the statute, but there are some commonalities across the kinds of statutes that we're talking about here that could relate to whistleblower actions. And then the other thing that I would say is, as a practical matter, U.S. enforcement agencies tend to take very, very broad views of jurisdiction. Now, that doesn't mean, of course, that if you are before such an agency and advocating in front of them, that you have to accept their view. But it is important to understand that, and particularly in the corporate resolution context, when companies decide to settle, sometimes you will see theories of jurisdiction in those settlements where there has not been litigation that can be extraordinarily aggressive and arguably might not survive if the case was litigated and went, before a federal court. in the US. But compromises are made sometimes. So that's just, as a practical matter, one has to assume that the DOJ or the SEC is going to take an aggressive view of the hook being so satisfied, and be prepared to, if there are arguments against that, be prepared with those arguments. In terms of the types of hooks, so they really, they boil down to a few things. First of all, if the conduct at issue or the alleged conduct has any sort of touch as far as arguably having occurred in the US, and it doesn't have to be the entire course of conduct. So let's just take a bribery scheme. If there was a meeting that occurred, maybe some of the people who are alleged to have been involved in the bribery scheme happened to have a single meeting in New York and discussed the business transaction that related to the bribery. That's the kind of thing that's going to be considered enough to trigger, and really it's a statutory matter. I mean, the argument would be pretty decent, that's going to trigger, that's conduct that occurred in the US that related to the scheme. So that's, conducts within the US. And in our global economy, of course, there are many situations where you will have executives who may be largely sitting in, say, India and doing their work, but they might have a business meeting in New York or in Miami or in, so anything that happens in New York that's related to, in the US that relates to the scheme. There's also the concept of interstate commerce, which is very, very critical. So that would be monetary transactions as well as communications, like the use of email or the phones, or perhaps video, where there's those kinds of transactions into and outside of, going into and coming out of the US, again, that are related to the conduct. And when I say related to the conduct, I mean either specifically to the alleged illegal scheme, whatever it is, or to the business transaction to which the scheme relates. The other type of hook that is very, very common, and applies specifically to any companies that are listed in the United States on the stock exchange. So foreign issuers, there you're going to have jurisdiction very easily for anything that relates to the securities laws, anything that relates to FCPA as well, anything that relates to accounting issues. Those, because they're listed in US stock exchanges, that the hook is going to be there. And then there is finally transactions with the US government. So that could be if you are a company that's in the supply chain for a US government contractor and therefore is being paid by US government funds. A company that is in, say, the healthcare industry and might be receiving US government funding. And then finally, in the trade context, companies that are importing into the US and thereby physically touching the US. But then if there is an attempt to, for example, evade customs and tariff duties, that's going to be sufficient to trigger jurisdiction. We also see, as they say, in terms of some of the aggressive theories, we see the enforcement agencies relying on things like, okay, US dollar transactions. Any transaction that is in US dollars is going to have to go through a US correspondent bank account. And if that is related to the alleged scheme, that's going to be viewed as one of the hooks for jurisdiction. We've even seen cases where sending emails or instant messaging, WhatsApp, what have you, where those messages happen to go through US-based servers. Obviously not something that you as a user would know or be able to control. That's something you see cited in some of the more aggressive theories. And then finally, again, in terms of things that you can see cited, is we've seen cases where actions where there's an allegation of conspiracy, so that there are, a number of people are involved in the alleged scheme, and maybe some of the alleged members of the conspiracy have engaged in actions in the US and others have not. But yet, because they're alleged to be part of a conspiracy, the Department of Justice will attempt to say, we don't care if you, conspirator number 3, never set foot in the US in any way related to this issue. You conspired with people who did, therefore we're in it. Now that's something that we as advocates would, I think, argue pretty aggressively against, but those are theories that you see. So these can then manifest themselves in FCPA cases, False Claims Act cases, like Pat was mentioning, securities related cases, and all of the other types of cases where the whistleblower programs exist.
And if I can make just one more point on that, is that with respect to everything Iris and I have said, there is nothing in any of these whistleblower programs. There are certain restrictions on the types of whistleblowers that can avail themselves of these programs, but there is no limitation as to whether the whistleblower is a non-US person or a non-US company. So anyone, anywhere around the world, as long as they meet the other requirements of eligibility under these programs, is going to be able to avail themselves of the programs.
Understood. Thank you, Iris and Patrick. So I understand that we understand the US nexus now and the jurisdictional hooks. So moving forward, our question is what happens next after a tip is made? Many companies assume that they will know immediately or they can contain the issue internally, but that may not be the reality. Patrick, could you take the next question? Once an external tip is made in the US, what happens next and what does that mean for an India headquartered group?
Right. So under most of these in fact, all of these programs, unless the company has a hint through internal reporting that there may be an external reporting, the company will not be alerted to the external reporting. They certainly won't be alerted by the government receiving the report. What will happen is that whether it's the SEC or DOJ, there will be an internal assessment as to the merits of the allegations. And some allegations are, as written on their face, facially implausible as a legal matter. Those will be put aside. A lot of these submissions contain, all are accompanied by internal documentation. That's certainly the case under the False Claims Act, which almost in many instances requires it. So they will look at the documentation to see if there's any there, so to speak. Once they've determined that that this is a case worth investigating, they will formally open up an investigation. But they will do so covertly in the first instance. They won't reach out to the company. What they will do is they will do they may check government databases for corroborating evidence. That's particularly true in the trade fraud context, where they'll, if there's an allegation of avoided customs, they'll contact CBP and see what the customs data says. They will remain, the word we use is covert. They will remain covert until they are ready to serve a subpoena on the government. On the defendant, the defendant that's the subject of the allegations. Exactly right. And that'll come in the way of, that'll be a formal subpoena. It could be on their registered agent. It could be a call to the GC. Hey, we have a subpoena. Do you agree to accept service? They may also start reaching out to former employees before that ever happens. So, with respect to an Indian company, they may have a registered agent that accepts service in the United States. They may have a U.S. subsidiary, but that will be essentially how an India headquartered company catches wind of an investigation, which also sort of, because the investigation will have progressed by the time the company learns of this. If there's a sniff that an internal reporting is going to become an external reporting, the company has to take those allegations very seriously and get in front of the allegations, so that it can decide whether or not it makes sense to proactively disclose or remediate.
Yeah. So I believe that your answer sort of highlights why the first week can be so decisive. And even if a company is still debating whether the complaint is serious or not, an external process may already be moving and it may be underway. So Iris, let me ask you about what tends to go wrong in that first week, and what do companies do in the first week that inadvertently make US exposure so much worse?
Sure. And I'm gonna focus on, because of what Pat mentioned, which is that I'm gonna focus on the first week after getting an internal report, since, as Pat mentioned, and as you mentioned, Susanna, as far as the external report going to the government, in most situations, you're not going to know. So you won't know you're in the first week. But in terms of an internal report that's a serious one and looks like it might be credible, I would put it into two categories: things that that companies do that inadvertently make the U.S. exposure greater, or that should be avoided. One is any actions that increase the likelihood of the whistleblower making an external report. Now, it is very important and I'm sure that this audience is very well familiar with the fact that it is improper and, under U.S. laws, it is illegal to attempt to interfere with an internal reporter and their ability to go to a U.S. government agency. They cannot be told not to do that or pressured not to do that. However, in terms of managing an internal reporter, there can be measures taken to try and help them feel heard, manage the psychology of the situation. Often folks who come forward, they may be emotional, they may feel under stress, they may feel that they are at risk of retaliation or have already been retaliated against or bullied by their boss or whoever they're making the allegation against. And in that first week, you're probably not going to know whether those concerns that they may have are valid, but you have to very carefully manage that situation with the whistleblower, help them feel heard, help them feel protected, and also, in addition to the direct dealings with them, whether they've remained anonymous internally, but you have some kind of interaction, or whether they've identified themselves, also manage let's say, the work ecosystem around them. So identify quickly who is it within the company that needs to know about this matter and what's happening, and who is it very important that they should not know, and manage that situation. So as a quick example, just a recent matter that we've handled, an internal reporter came forward to the international headquarters of the company about issues at a subsidiary in another country. And so in order to look at the issues, that involved looking at issues at the subsidiary. However, the reporter is sitting at the subsidiary making allegations against people at the subsidiary, reporting up to the headquarters. So then you have to figure out, all right, how are we going to get the information we need at the subsidiary level? The headquarters doesn't have the information, but you have to very carefully analyze who can we even talk to at the subsidiary level? Because if information gets out to a group that shouldn't have it, then either there could actually be retaliation, or it could look like there was retaliation. So managing that whistleblower to prevent, to mitigate the risk that they will go externally, managing that in appropriate ways. And then very quickly, the second thing I was going to say is that, and this actually applies both to whistleblower matters and other ways that cases can come forward. But again, because in a whistleblower matter, you have that increased risk that they're going to go outside to the government to report. The second thing is that it's very important to quickly assess, are we dealing with an allegation of entirely historical conduct that is in the past, or are we dealing with something that relates to an ongoing set of business transactions? Why is that important? Because if there is misconduct for ongoing business transactions, then the company, as soon as there's enough evidence to conclude there's likely a problem, the company needs to think about taking steps to extricate itself. So, if it's a bribery, the very earliest case I was ever involved in, this was a lesson that I learned, because it was an ongoing business transaction, a foreign bribery case. What did we do when we found out there was evidence to be concerned that this was really a problem? The company took steps to stop accepting payment from that foreign government customer. Why? Because accepting further payments was going to be continuing the conspiracy and continuing the liability with the U.S. government. So that's also very, very important.
And Iris, that sort of crashes right into your question about, right into your point about how hard it can be to maintain confidentialities, right? If you're withdrawing from a transaction or a business relationship, you have to do so delicately in order to keep the keep the zone of confidentiality intact.
Yeah, that's very true.
Yeah. Definitely. And that entire point brings us directly to the in-house reality, because it seems like the most effective way to manage an escalation risk is a fast, credible internal response that sort of preserves evidence and maintains fairness, avoids inconsistent narratives. So, Prem, let's turn to the practical GC perspective. And my question to you is that what are the first 3 decisions you make in the first 24 hours after a serious whistleblower complaint lands?
Thanks, Suzanne. I think that's a great question and a very practical situation. So, from an in-house perspective, as soon as a whistleblower, serious whistleblower, first the triage should to reach to a conclusion that whether it's a serious whistleblower or not. But as soon as it is established or it is decided that it is a serious whistleblower allegation or accusation is there, first step is to the data preservation. All the related data from of different sources, whether it is email, chat, financial records, documents, everything from soft copies to hard copies, that needs to be preserved. And it should be access controlled so that it can be proven at the later stage that the records are not manipulated. So data preservation is the first and foremost thing to ensure. Second is to establish the governance and independence, to decide that who will oversee the fact gathering exercise involving compliance team, legal team, internal team, and sometimes we also take support from the other functions like finance, different functions which are involved who are having the data. And rightly, as Iris pointed out, maintaining the confidentiality, that without letting everybody and anybody know that why the data has been collected. It's a very important thing to maintain that part as well for the right governance as well as the independence of the investigation process. And the third important aspect of this is the communication disciplines. The very important is to limit the free form of discussions everywhere and set a very clear internal protocol for the questions and updates somewhere, whether we need to proactively disclose to whom, when, and how, and who should do that. And at the same time, somewhere we need to do it reactively only, and that the reactive statements and the narratives should be ready. I think very important aspect also is that how is to ensure that there is no inadvertent action which might be perceived by the whistleblower as a retaliation, either whistleblower or some of the witnesses who might not be even knowing that there is a whistleblower already happened. But if there are something happening, how to do that, I think that's a very important, and it depends upon the situation to situation, and that needs to be very carefully navigated, that how even a perception of being retaliation can land later into the trouble to the organization, not a very deliberate attempt to retaliate, but even any action or impression which can be perceived as retaliation by either the whistleblower or the witnesses can land into different problem. And I think these are not very dramatic steps, but these are the foundational and fundamental steps to establish a credible process and the credible defense if the external scrutiny emerges or comes the way of the company.
Sure. As you rightly pointed out, speed is critical, but so is credibility. One point that you pointed out was that there should be no perception of retaliation. Another side of that coin is the fact that although there's no perception of retaliation, but a lot of times when we're investigating, people perceive that, or at least they think that we are rushing to a judgment, or there is, it's an unfair process, or it's a predetermined outcome already. So how do you move quickly without creating that impression of a predetermined outcome or an unfair process?
That's very good question, Sujan. I think the speed should not mean that rushing to conclusion. The speed here should refer to the rushing to the structure, finalizing the structure in terms of, as I say, that the good approach, the preliminary credibility and the scoping assessment, the scope of the allegation, the scope of the investigation, what to investigate, where the data is. I think speed to decide that the putting to a credible structure is important, and then a deeper investigation plan, proper investigation plan, what to investigate once you have all the source of information, and have a plan to investigate properly and proportionate to the risk which is coming out of the investigation. This early steps should be process driven, preserve data, identify stakeholders, define allegations precisely, and document where you know and what you don't know, what you don't know. So based on the available information, what are the knowledge you are having about the allegations, what are the misconducts, what are the available, and what need to be discovered. And in order to discover that, what data and information required that. I think speed is required to find that structure as quickly as possible and not to just jump on the conclusion, predetermined conclusion. And that is why it is important to have to avoid any premature messaging, because that can sound like a blame, or it can be misinterpreted by the people. And the goal in the first few days, hours, or 21 day, 2 day, 3 day is to create a controlled environment where facts can be gathered fairly, consistently, rather than to close the matter. I think the difference is the perception. When the perception is that the steps are taken just to tick in the box and close the matter without any meaningful outcome. The reality is that the steps to be taken to give a perception that it is a very thorough approach, it is well thought through approach, and it is not to close the matter, but it is to investigate and conclude the matter in a meaningful way.
Yeah,
So
thank you.
once
Yeah.
I can't help myself but ask a question. First to Prem, in your experience with speed, when do you want to bring in external counsel in?
So again, it depends upon the situation, the nature of this thing. And again, if it is a serious, assuming that it is a serious, I think it is as soon as possible. And to if I have to make a decision, it is within first 1 or 2 days.
1 or 2 days. And I now ask my friends Iris and Pat, when do you think external counsel should come in? Within the first 24 hours, lesser, 48 hours? What would be your advice to someone like Prem who's on the inside?
Sure. So, I think relatively quickly. I think that a lot of it will depend on the size of the in-house staff, where the issue touches. The closer the conduct touches the legal office, the sooner you want outside counsel involved. And if you think that this is going to be reported relatively, soon, the sooner the better in terms of getting U.S. counsel involved, because there are benefits to being, should you decide to do a voluntary self-disclosure, there are benefits. The way you get the biggest benefit from that is to beat someone else to the door. And so I think you need to do this relatively quickly, but I think there are certainly facts and circumstances that will guide this in terms of specifics.
But I'll just share some Indian experience. In my personal experience, I've seen we are brought in maybe within the first 1 hour in many cases. So that's why I was asking the experience which you have from US and Prem you have overseas. In the Indian context, any such complaint, we are in really quickly, because even the company senior management understands that if a complaint like this has come, there are so many levels of disclosures and compliances, you better get the team in place. So that was it from my side. Susanna, back to you.
Yes, thank you. So Prem, you touched upon a very important issue, which is messaging. And you spoke about consistent messaging. So let's then move forward to cross-border consistency, because once there are multiple jurisdictions involved, different teams may engage different stakeholders, and small inconsistencies can also snowball. So building on what you just said, how do you prevent inconsistent narratives across jurisdictions once the matter has cross-border implications?
Great. That's a great question, Suzanne. To me, the single most effective tool in all these situations is to maintain the single source of truth in terms of the timelines, allegations, statement, and preferably owned by the legal team with or without the help of external counsel wherever appropriate. That does not mean a very rigid scripting that putting a script every time. What it means is that the organization has one agreed set of known facts. Many times in a short turnaround time, as I said previously, and many speakers have articulated on that, is not within 1 day, 2 day, or 1 week you get or gather all the facts. So based on whatever the gathered fact you have, and based on that, whatever the single a structured list of open questions, one protocol, who to speak whom. Because there might be various stakeholders involved in this, required to be informed on the need basis, some proactively, some reactively. And who is going to speak on what direction? It should be based on the single source of truth, which needs to be built with the credible level of information and in a consistent and a concise manner. We also need to decide the people, not, as I said in the previously, the free form of discussion. Everybody started to speak with anybody about these things, that who is going to speak, that needs to be decided. And consistency is critical because once a whistleblower goes external, any inconsistency of the statement, even if it is inadvertent, by the regulator or external forces, external investigators, it will be seen or at least perceived as concealment or trying to manipulate the facts, even if it is simply because of the lack of information or internal confusion. So from an external lens, any kind of inconsistency in the statement or the communication will be misinterpreted and interpreted differently. Sometimes it's concealment, sometimes it's an evasive attitude. So in order to avoid that, it is very important that the source of truth is established with the timelines and the allegation statements, preferably reviewed, owned by legal, with or without the help of external counsel.
Yes, thank you so much. That was very helpful. I think that leads neatly into the India governance baseline. In India, of course, whistleblowing is not just a policy issue for many companies. There are clear governance expectations around vigil mechanisms, safeguards against victimization, like you said, non-retaliation, and escalation routes. I will just cover the India lens briefly now, and then we can move on to a closing segment on cross-border readiness. So just let me quickly summarize the India governance baseline at a high level from a very, very practical perspective. Firstly, many organizations in India, particularly listed entities, are expected or legally required to have a vigil mechanism or a whistleblower framework that allows concerns to be raised and provides safeguards against victimization. In practice, the value of this framework is not the policy document itself. It's usually whether employees and third parties believe that they can safely sort of blow the whistle and whether the organization can demonstrate that it responds in a structured and a fair way. Second, what matters most from a governance standpoint is credible oversight and escalation, and all of you spoke about it. Sensitive matters such as allegations involving senior management, significant fraud, financial reporting risk, retaliation concerns should have a clear path to independent oversight, typically through the audit committee in India. The key is that organization can show that complaint was not filtered through potentially conflicted management, which we have seen in quite a few cases that we are doing, and that every decision was documented. Third, technically, when you overlay with what Patrick and Iris described about US programs and incentives, the India framework becomes important. Internal processes need to be credible and quick to maintain trust. If reporters perceive delay, when I say reporter, a whistleblower, when they perceive delay, lack of independence or they fear retaliation, like you said, Prem, external reporting becomes more attractive. And once external reporting occurs, the organization is managing a multi-jurisdictional event. So the India baseline is not only compliance, it's basically cross-border risk management. With that, let's move to our final segment. Basically, what breaks under pressure when a whistleblower or when whistleblower matters are cross-border and how organizations to prepare. So my question to you both, Pat and Iris, is if you had to name the top cross-border issue that breaks under pressure, what would it be and how should companies prepare for it?
Well, I think there's probably a couple that come to mind. One is, I'll start with one and then I'm sure, and then Pat will chime in. I think that managing, particularly if you're managing across different parts of a company that are in different parts of the world. And then it becomes particularly difficult to manage the communications from a cultural, psychological, and privilege point of view with the whistleblower, the reporter themselves, assuming you're in touch with them. So if they have made a report that has some credibility to it and that they care a lot about and are considering going to the government about, then you're going to have to manage what you tell them, what you don't tell them, knowing that things that are told to the reporter themselves, they're probably going to be eager for information. But you have to be very careful to not tell them anything that you wouldn't want to be disclosed externally, because you're not going to be able to control that. And that's particularly, we've seen that, and I've seen that, and we've seen that. Those tensions are particularly heightened when you're talking across an organization. So say you have, you're sitting in one country, and then you have a reporter who's sitting at a subsidiary in China or in Nepal or in some, an African country, and you have to manage that information flow with them, as well as recognizing that the privilege laws may be different. So that's where things can really go fatally wrong if they're not carefully managed in terms of what you are telling and not telling to the reporter themselves at different points in the process as well, both during and then once you've concluded.
Yeah, and I'd only add that, there could, problems can arise when there's not a integrated approach or sort of thinking about issues in a multi-jurisdictional perspective about disclosure, voluntary disclosures. As I mentioned, voluntary self-disclosures in the United States are most beneficial when they're done quickly. But there are often ancillary consequences to making those disclosures. They may trigger disclosure obligations, for example, under the Indian or local securities laws. They may require disclosure to auditors. They may alert, that information may alert, DOJ, after this disclosure is made, may reach out to the Indian government, and all of a sudden you're looking at a dawn raid of some sort, or some sort of investigative action that you hadn't anticipated domestically. So I think the way you avoid these types of issues going south is you really have to think about, U.S. counsel, certainly has to work with Indian counsel on, okay, here's the approach. What are going to be the consequences in each jurisdiction?
Wow. So thank you for that. I think that gives us a clear sense of what to prioritize. But I want to end this discussion with a clear roadmap for companies. So Prem, my last question is to you. What does a concrete roadmap for borderless whistleblowing actually look like for a cross-border business like yours? Prem, you're muted.
Sorry. Thanks. I think it's a matter of putting a structure and then practicing it well. So the concrete roadmap for borderless whistleblower is having 3 layers. The first is the program design, where there are credible intake channels. There are non-retaliation controls, effective, not just on the paper-based, and independent governance, so that internal reporting is still viable despite the external incentives exist in the various forms and shapes. The second is incident response, a well-rehearsed 72-hour playbook covering preservation, triage, escalation pathways to different committees, like audit committees or the various levels across the corporate office, from the subsidiary to corporates, and the communication protocols. Maintaining that discipline around is very important. And the third is the cross-border integration. Early alignment on the privilege strategy, data handling, witness preparation, and regulator sequencing is very important. I think these are the 3 layers which are very important. And when these 3 layers are in place, in both in the structure as well practiced. Organizations do not, or the companies who face these kind of situations, as and when many of us have experienced in that, organizations are not trying to invent the process during the crisis time. They are actually executing the plan which is well established, already in place. And this is what exactly the external stakeholders look for when there is a external investigation. So when the final message from my side is that when a whistleblower becomes cross-border, process disciplines becomes evidence for the external stakeholders, that how disciplined your process are, whether it is just as a paper-based tick box approach or whether it is actually a disciplined approach and it is feasible to them. It is at that point of time, it is not important what is inside, how you demonstrate that to the external stakeholders. And then companies are judged on the basis not only of what happened, but how quickly and consistently and credibly they respond to the external inquiries.
Thank you so much. So from what I gather, I think we can close with 4 simple takeaways from today. First is that we all have to assume that whistleblowing is borderless now. External reporting can happen early and sometimes even before facts are stabilized internally. Secondly, credibility is everything. Internal mechanisms must feel safe and independent with real non-retaliation protections. Thirdly, like Prem said, the first 72 hours matter. In fact, they matter the most. So preserve data, establish governance and control mechanisms and communications before narratives drift, and there should be clear messaging. And fourth, and most importantly, we have to treat it as a cross-border issue from day one. Maintain one source of truth, align privilege and data handling, and sequence stakeholder communications carefully. So with that, I think we end our session. The closing remarks will be given by Mr. Ajay Bhargav. So, sir, over to you.
Thank you so much. I think for someone like me from outside, inside look, this has been so insightful. And I think it's so relevant in this day and age where we all use a terminology when we meet someone, what a small world. And what we have seen over the years, the world has actually become a global village with companies engaged in cross-border businesses. And what I hear is that an issue in one country today escalates to another country or countries in quick time because of the mode of communication which is available in this world today on social media, which is both a boon and a bane. And I feel that after hearing Pat, Iris, Prem, and Susanna, I think I need to go back to the books to learn more on this issue. But one thing I can say is what I have understood is one, in order and no order of priority, but a playbook for every organization is very important. And that playbook should crystallize your response time in the quickest possible time, I would say. 24-hour playbook, 48 hours or 72 hours, and then you have a properly designed process on how to take on such complaints with giving full comfort to the whistleblower, confidentiality, security of non-retaliation, and the rest of the things we heard on this event. But I think that's a wonderful insight to have. And I'm sure this is very helpful to our audience who has heard all of us quite nicely. And, I would thank the Indo-American Chamber for helping us to kind of put this event together. With that, I would say thank you, Pat, Iris, Prem, and of course, Susanna, for the lovely insight into the whole issue. Neeluji, and of course, Kashish and the team at Indo-American, thank you so much. And we should definitely keep this engagement on. Maybe after another few months, we should do a recap on this topic if there are any more evolutionary things in the world, anywhere in the world, and let's go for that again. With that, thank you so much, everyone. Neeluji, maybe you can step in.
Yeah, thank you so much for joining. Thank you so much, Susanna. Thanks, everybody. Thanks.
Thank you. Just one point for all our attendees. Steptoe has also prepared some slides. So I think for everybody who has attended, we will be circulating the slides to all of them. With that mail, we will also be circulating the email IDs and contact details of all the panelists. So in case somebody wants to reach out, they have some questions, they can reach out directly. And thank you so much, everyone, for joining. Thank you, of course, again to IACC, Mr. Singh and Dr. Bhasin for sort of setting the context and hosting this session. And of course, to our panelists for a very, very engaging discussion. Thank you all.
Thank you.
Thank you.
Thank
Thank
you.
you.
Thank you.
Thank you. Thank you. Bye-bye.
Thank you, everyone.
Stay on.